Please, my lord, I and Mr. Lutwe still appear on behalf of the state in this matter.
Yes, can I just confirm my appearances as before?
So confirmed.
Mr. Bukes?
Yes, may it please you, my lord, I appear on behalf of accused 4 and 24. As it pleases the court.
As the court pleases, my lord, I appear on behalf of the accused persons as before, and to them also standing in for Mr. Samherji.
Okay.
As the court pleases.
In respect of the gentleman, the doc, you are all here, isn't it? Mr. Gustavo, how are you feeling?
Well, I'm sure that you feel better than I do, but I'm better than I was last week. Thank you.
You know, you can never know, but I'm glad you are here and well.
Looks can be deceiving indeed.
Yes. All right, so everyone is present. Mr. Gustavo, appearing for yourself. Mr. Hatuikulipi, you didn't manage to be away, isn't it?
No, I did, Judge.
Oh, you've been there. You've been there.
Yes, I've been there.
Okay, good. And Mr. Mwatelula.
Present, Judge.
Yes. Yes. I think there was a general drift yesterday towards ensuring that we deal with the application for separation of trials. The general position, as I understood it from counsel and from the discussion generally, is that we must dispose of that application first. And I intend to set a timetable for that matter to be heard as soon as possible. The one point I can say is it's an application within a very narrow canvas. That's not a complex matter, isn't it? And we should be able to deal with it quickly. Unless there are other issues which we need to address, we'll deal with that first and set a timetable for that.
Lord, just also a brief issue concerning that particular application before we set time frames in respect of that application, my Lord. My Lord, I was unable to attend the proceedings for the past 2 days. That's why I requested Mr. Simunje to stand in for me. Now, my Lord, I only received the application for separation this morning, and I was able to take brief instructions from my client, accused 4, Mr. Esau. My Lord, we intend to make common cause with the applicants in respect of that application. And the basis for that, my Lord,
That's
is
accused 4 and
424. Now, my Lord, we were, in essence, ready to commence and to proceed with the trial. And just by way of a brief background, my Lord, accused 4 applied for legal aid. The legal aid application was rejected. We then also applied in terms of Section 26 of the Prevention of Organized Crime Act. We brought an application in the High Court for Mr. Esau's legal expenses to be paid from his restrained assets. That application, my Lord, was successful. The High Court on the 10th of July ordered that we be paid our outstanding legal fees as well as the legal fees in terms of moving forward with this trial. And on that basis, Mr. Esau thus secured his legal representation. However, my Lord, on the 9th of August, the Prosecutor General appealed the judgment of the High Court to the Supreme Court. And that, my Lord, brings us now back to square one. We are unable to say, we will file our notice to oppose today. I just managed to have Mr. Esau sign the power of attorney today. So we will file the notice to oppose today in the Supreme Court. But that would now mean, my Lord, we are in this vacuum of uncertainty. We do not know and cannot anticipate how long this appeal will take before the Supreme Court and whether we will be successful or not in the Supreme Court. And as a result thereof, my Lord, I would not be able, already having worked 3 years pro bono on this matter, so to say, without any payment, to continue right now with this trial until the decision of the until the Supreme Court has pronounced itself. And it's on that basis, my Lord, that my instructions are from Mr. Esau that we make common cause with the application and perhaps also just file a supporting affidavit. I don't think it will be necessary for us to file a new notice of motion. Obviously, with the court's guidance, if we can also just file an affidavit in support of the application of the other applicants, and then for that matter then to be heard as per the dates provided by the Honorable Court.
Which matter are you not going to continue to represent the accused? Which matter?
This matter, my Lord.
Which matter?
This criminal matter.
We have the application for separation of trial.
For the separation, and we want to join that application. My instructions are, let's join
Yes,
this application
yes. Can
for
you just,
separation.
yes, can you listen to the question?
Yes.
Are you continuing to represent Mr. Esau pro bono in respect of the application for separation of trials?
Not pro bono, my Lord. I'm just representing him in that application. Pro bono would imply that I will not be able to even get payment at the end.
Whatever, but
Yes.
in respect of that one, you will continue to represent him.
I will continue to represent him.
It is in respect of the main trial where you renounce the agents or what?
Yes, my Lord. I will not be able to proceed with the main trial until I've been sorted out the issue
but
of funds.
What is the position when a lawyer can't, no longer wishes to represent a client? What does he do?
You withdraw.
So what are you saying? In respect of the main trial, you will withdraw?
Yes, my Lord. But I will not withdraw immediately. What I intend to do is, I will obviously have to withdraw at the end of the day, my Lord. But for the purposes of the separation application, I'm in a position to assist Mr. Esau.
And can I take can I be sure that I'm taking down what you are saying correctly? And in respect of the main trial, you are going to file your notice of renunciation of agency.
My Lord, after the separation
Yeah, that's why I'm talking about the
Yes,
future.
my Lord.
I use the future tense to say you will.
I will.
You are putting me on notice that you will renounce agency in respect of the main trial.
Indeed, my Lord.
I hope you will continue to represent him in the Supreme Court.
Indeed, my Lord, because my interests they are at stake, particularly in respect of my arrear fees, my Lord, and they are quite significant. So I will continue. But that's the civil matter in the Supreme Court.
So you choose one and say, I respect of these other two, I will continue to represent him, but on the main trial, I will not.
My Lord, the Supreme Court one is I will be one day in court. We will file papers
So
interchangeably.
the effect of the appeal is to suspend the order, isn't it?
Yes. Which order, my Lord?
The order made granting Mr. Esau his money. The High Court order.
Yes,
So-
from the PG side.
No, my question is, the noting of the appeal suspends that decision, isn't it? Or the High Court
Suspends.
decision.
Suspend that
In other
decision.
words, you can't now receive your money.
My Lord, I also do intend to bring, but that is between my client and I, a Rule 21 application in the interim to see whether we can enforce that order.
Oh, I see.
Yes.
But the effect is that it suspends.
It's suspended, my Lord.
So of the three matters in which you are presently representing Mr. Esau, it is only the main trial where you intend to renounce agency if you are not assured of your fees.
Most certainly, my Lord,
Yes.
as it pleases the court. Anything else, my Lord? Anything else?
Oh, from the court?
Yes, from the court.
The court will will ask you when they need anything else.
As it pleases, my Lord.
All right. Timelines with a view to hearing the matter by the 13th. Do you want me to give you my proposed dates? This application was received, except for Mr. Bucas. I don't know why it took so long, but it was received by all the parties on the 2nd of September, correct? You were served with the application on the 2nd.
On the 3rd.
What do you mean on the 3rd? The 3rd
Well,
was
given
yes,
in court, yes, but the office was served on the 3rd, my Lord.
but you were in possession of the application on the 2nd.
On the 2nd, that's correct.
All right. My proposed timetable is the following, and I would want to hear your views. The response by the state or any other party to be filed by the 9th of September. By midday on the 9th of September. I propose that the reply, and knowing what a reply is, be filed on the 11th. And that the hearing be on the 13th. Written submissions can be filed if you so please, but I'm quite happy to receive oral submissions. If you didn't hear me, Mr. Marondez, I'm saying I don't insist on written submissions or written heads of argument. I'm quite happy to receive oral submissions.
As the court pleases, my Lord.
But if any of the parties is able to file or willing to file his heads of argument by the time of the hearing, I would be grateful if I could receive them by the day before the hearing.
As the court, please, madam.
You're happy with the timetable? Not happy. No one is ever happy to do any work.
Yes,
But
we'll be able to comply with the.
and as I said,
with the
this is a
directives, madam.
fairly straightforward application in terms of its, I don't know whether I can say, maybe it's complex from a judge's point of view where he has to write a judgment, but from the point of view of the parties, it's an application for separation of trials, and it shouldn't be a complex matter at all. Now, before I come back, I start with you. That is in order, Mr. I don't know what your position is with respect to the application.
My Lord, as I indicated yesterday, my position is clear. We want to commence with this matter as soon as possible. I've listened as far as the dates 9, 11, 13 is concerned. We also reserve our right whether or not to form part of this application, but I will receive instructions in due course. But as it stands, we would not be part of this application.
We know Mr. Pukas, that's fine.
Yes, my Lord, and I can also assume that if we are not party to this application, then there would be no need for me to be in court on 13 next week, Friday, 30th.
Yeah, it stands to reason. I never compare anyone who is not in.
Indeed, sir.
Yeah.
I just want to put that on record
You,
as well,
you,
because
you
we are
may
not
come,
party to
if
that.
you are not part of a proceeding, you may come, you may decide to stay away.
As the court pleases.
Yes. Mr. Bukas, you have said you are making common cause with the application, isn't it?
Indeed, my Lord.
So the days for when do you propose to file whatever documents you intend to file?
My Lord, I just have one request. If I can maybe just file on the 10th, our affidavit, given the fact that I've only received it today.
Yeah, but I received that application. In an hour's time, I had gone through it. You mean you need, I don't talk about drafting the response or the whatever papers you intend to file. That might take a few days. But between now and Monday, are you unable to do that?
My Lord, I'm flying out tomorrow for another matter, my Lord, to the north. And then I will only be back on Saturday.
Yeah, we all carry our work with us.
Apologies?
We normally carry our work with us.
My Lord, I'm going for work. It's not a jolly ride, so...
No, I know. But if you have 10 files, you carry as many as you can. But anyway, the point is you are making common cause. I don't know whether I will make any additions, but I would rather, for a proper consideration of your papers, I would rather you file by the 9th.
In the hands of the court, as it pleases the court.
Yes. You'll have to work overnight, and that ensures more fees.
Pro bono, my Lord.
Right. Mr. Gustavo, yes?
My Lord, if Mr. Bukas is filing on the 9th, we would need to see the facts on which he is making common cause with the application.
Maybe
so that
we'll
we can
file
include-
tomorrow. I said by the 9th. Maybe we'll file tomorrow.
Yeah, but okay, whatever day he files, my Lord, can we be allowed to file a day after he has filed so that we can incorporate our response to whatever he has filed, my Lord?
The main file has been filed by the 3, isn't it? He wants to identify himself with that one. Perhaps you will make
He might raise some new facts, my Lord, which we might need to respond to.
in respect of who? In respect of his,
Yes, with these applications.
in respect of his client.
Yes.
Well, Mr. Bukas, you can see the complication that arises here. Remember, as far as this case was concerned, why I'm putting these timelines, I had ordered that this matter is to proceed the whole of this week. You remember that?
Yes, my lord.
Yes, and that is why I am of the view that you would have devoted time for this matter for this week, and that is why I am requiring papers to be filed as soon as possible.
My lord, may I just briefly respond to that, my lord?
To the order or what?
Yes, for this week. My lord, I fully understand, and we try our level best to comply with the court order. This matter was set down, if I'm not mistaken, last week for this week and another 4 days in next week, 9 days. My lord, I have a diary that also has other high court matters in it. That was scheduled already in June and July, and some of them even in April. And now this honorable court has made an order to say that for the next 9 days you must be here. Unfortunately, my lord, we also have other scheduled matters. We also have other court orders that we have to comply with. We were not allowed an opportunity to give insight in terms of...
Are you inviting me to go back on that order or what?
Not at all, my lord.
Yes.
All that I'm saying is, my lord, is...
We will take due account in future. That's why when we are planning for a case, we must all be here.
Indeed, my lord.
And if I remember well, you were not here when Mr. Siomunji was standing in for you, isn't it?
Yes, my lord.
So, that is water under the bridge as far as I'm concerned. But anyway, I'm trying to explain why I consider that you have time, because that was the order I had made, that this matter will proceed between the 2nd and the 6th, and then the 10th to the 13th.
But most certainly, my lord, I must also be allowed an opportunity to explain why I'm not available. Even though the court has made an order, I'm explaining to the court there are other court orders also. There are other matters that I have to attend to. Normally what we would do is we would agree on the dates, everyone. But now we are just given 9 dates out of our schedule that we must just drop everything else. Other judges are also expecting me to comply with their court orders. So I'm in a conundrum where I'm asking the court, give me 1 day.
I can understand your position. But when the order was made, you were not here, Mr. Pukas. Mr. Siomunji was standing for you.
Indeed, my lord.
Now, if you are not happy with my court orders, please, we know what to do. It doesn't matter what nature of order it is. If you are not happy with if you are aggrieved by any order I make, you know what your rights are.
Indeed, my lord.
Yes. I can't go back on orders that I become functus.
My lord, I understand. All that we were asking the honorable court is just to give us an indulgence with 1 day. And what we are saying is, my lord, that request is not unreasonable. We are trying our level best to comply with this honorable court's orders.
Which 1 day you need?
The indulgence that I've asked, my lord, is not to file on the 9th, to file on the 10th.
But you must understand that it's not only your interest which we take care of. We also take the interest of the state. They need time, assuming you come up with different angles, they need time to consider that.
Yes, my lord.
All I can say is that I will allow the state, in the event that there are issues that are peculiar to your identification with the existing application, I will give them an opportunity to file a supplementary answering affidavit.
As it please the court.
But when I say by the 9th, I mean by the 9th. That is, you may file tomorrow, the following day, but by the 9th, your application must be filed.
My lord, yes.
Yes.
I understand.
Mr. Gustavo.
Yes, Judge.
Yes. You must have received an application by Mr. Shanghala, Mr. James Hatuikulipi, and Mr. Mwatelula.
Yes.
Yeah. It is the application, if you have been listening, for instance, Mr. Esau wants to make common cause with. One of the reasons I postponed the matter to today was to hear from you. There's this application for separation of trials, and I don't know if you considered what your attitude will be.
Yeah, thanks. So I only received the application yesterday evening when I came back from the hospital. And I've been following the discussion now that you had with the defense counsels as well as the state. I just want to understand, by the way, just so I'm clear. The state's response, or any other parties, you are saying the 9th of September.
Yes.
Then you set the hearing date for the 13th of September.
Yes.
And any written submissions or heads a day before, so on the 12th of September.
Yeah, whoever wants to. But as I said, I make it easy for everybody. I make it easier for everybody. You can just make your oral submissions. I'll be quite happy to receive them.
Without submitting any heads or...
It's up to the party. I have said you're at liberty to file written heads of argument. You're at liberty to make oral submissions.
Okay. Now, I understand, my lord, and I have a problem with what you've just sort of articulated. I have a challenge with that. My understanding is that I have 14 days in which to respond. And I would like to have the court consider to allocate me those 14 days for the simple reason, or for the following reasons. Perhaps one, I've not been well, and I think just to follow court proceedings, etc. I mean, you know that after our last meeting here on the 27th, I was hospitalized immediately. I only received those documents, as I said yesterday. I didn't even look at them because I was just not feeling well. I went to bed. So I have to apply myself. And I would appreciate the court to indulge me with the full allocation of those 14 days to decide. There's so many things I have to decide. I looked at it this morning. You know, what does a separation mean? I don't know. I'm self-represented. I have to go and read these things, read and sort of study, understand what it means, what are the implications towards my case, what are the implications going forward, and I don't want to make cause with anything without having applied myself to the correct degree. That's my position, just following what you're saying. And I think if I look at the dates that you've put here, I think that's what, Monday is the 9th already. Today is the 4th, so that's 5 days. It's less than 10 days that I'm expected to sort of sit down, make heads or tail of Section 157. Draft and understand what the implications are to myself in this matter, and then be able to coherently, my lord, come before you and provide you with something that is substantive and that will not waste the court's time. I've noticed that the defense counsels don't have an issue with that because that's what they've been trained to do, isn't it? They've been trained to understand, read per minute, per second, and understand and be able to sort of come up with something coherent. That's why Mr. Bakers is probably already to make cause with. I'm not at that point. I have to go and read this, understand, and be able to come up with something substantive to the court.
Yeah, all I can say is that I'm not here concerned with your application. I'm concerned with an application by 3 of your colleagues. That's the application which is before me. Right. And it has been served on the parties. One of the parties has said, we have nothing to do with it, we are not going to participate. I don't know what your attitude is. So all I'm simply saying is, I'm setting a timetable for an application that has been placed before me, which must be heard and disposed of within 30 days. That is why I took a tail the number of days within which ordinarily in civil matters you would be required to file papers. So,
What if, my lord, I do become an applicant? What if my attitude then, after 14 days, I say, you know what, maybe it makes sense for me to join this application. I become an applicant before you. Does that change your thinking?
I deal with matters as they arise.
Great. That's why I'm saying that I think by the rules of this court, I'm allowed 14 days to consider whether I'd like to make cause with this application or not. Are you saying that you are taking that away? You are giving me 9 days or 8 days, I think it is, to make that decision? And you are saying that because I'm not an applicant before you, it doesn't matter either way. Is that my understanding?
What I've said, Mr. Gustavo, is I'm setting a timetable for an application before me. And that timetable is what I've set out. And we proceed accordingly. If there are any difficulties that we will encounter along the way, we deal with them.
Yeah. Well, I think it's, and I hear you. I hear that you've set your timetable for your court. That's fine. But where I find myself, and I think I've articulated this to you before, the attitude that the court is taking is rather unfortunate. I cannot push that any further, my lord. I'll leave it there.
Thank you. Unless there's any other matter?
Yes, Judge.
Yes.
After all, I thought I am the dominus litis in the application.
Yes.
Or has it become the court's application now? I don't know. Judge, yesterday when I addressed you, I had asked you that you please consider the unique circumstances in which I find myself. It's clear I'm behind a cage, and your vista, your view of me is that I'm some thug behind the, this is what it's meant to do. But forget about that. I am actually in a detention facility, in the Window Correctional Facility. In that facility, I'm kept at a different unit. My co-applicants are kept at a different unit. When I looked at the timeline and I made the application and set the timelines, I was trying to factor in the practical reality of being able to consult with my co-applicants and craft our papers. You've just run roughshod over what I have explained to you yesterday. This after you admonished me when I said that the court is uber alles intended upon rushing into, I was talking about the main trial, now even this matter. So the court wants to do it in a jiffy without due regard to the submissions made, not only from myself, but Mr. Gustavo, not only us, but also defense counsel. So judicial committee, I say nothing about that. Judicial committee is no longer an issue in Namibia, it seems. But Judge, I want to understand what it is we're trying to achieve. Are we just ticking boxes off? I've heard them tick off. I've given them days, tick off. The substance, I'm not able to receive papers on Monday and produce a response on Wednesday. I'm not able to do that. I've given you the facts about my condition. In fact, there is a case about it that we cannot start trial with the difficulty we have. Being separated, people are at echo, people are at C-section, we cannot consult, we're charged with common purpose. You just want to tick off and go ahead. It's really unfortunate, Judge, because right now, and you were about to just hit the gavel. I'm the dominus litis, we're the applicants, but the judge has sort of appropriated the case.
I proceed on the basis that when you make an application, you want each head.
Yes. And as I told you yesterday, Judge, speedy trial, uber alles, does not give me a substantively fair trial.
Well,
And I'm telling you now that I will not be given, I would not have been given a fair opportunity to assess, consider, draft, and submit a reply upon the positions that I'm most likely will get. You heard what Marondetse was saying, Mr. Marondetse was saying the other day. He was saying, throw it out. They can bring it. I would need to consider what he writes, how he puts it, do the research that I must do, in the conditions that I am, which you are very well aware, because that case came to your chambers and it was thrown out of your chambers, heard by Judge Masuku, thrown out there. It's before Judge Boas Usiku, thrown out on urgency. It's pending because it affects the ability to have a fair trial. People are I must consult with my co-applicants. How am I going to consult? Are you going to make an order that remove them from ECHO, bring them back to C-section because we have an ongoing matter? You won't. And if you won't do that, how is that a fair trial? These are facts. You were saying I should give you facts. I must not assume wrong impressions and then run with them. I'm giving you facts. Well, how is this going to be a fair trial in respect of this application? How will it be if you are not willing to consider the circumstances in which I, the applicant, come to you before the court? Judge, I plead to you. I understand maybe you have a set mindset. I want to get on with it at all costs, but please, not at the cost of the substance of justice.
Mr. Shanghala.
Please.
I don't want to get a mindset that any of the parties here don't want this trial to proceed. I don't want to get that into my mind. Just as I try to disabuse you of the notion that this court is intent on speedily dealing with the matter, regardless of everything else. I too do not want to get any impression or any thinking that the parties are unwilling to have this matter disposed of within a reasonable time. What informs me is that, I think I'm correct, all of you have been in custody now for over 4 years. Is it wrong for a judge to try and ensure that you are brought to trial so that if you didn't commit the offenses charged against you, you are released? You have been in custody now for over 4 years. And all I'm trying to do, to the best of my abilities, to ensure that this matter moves on. You make an application, I tell you, right, let's hear your application as quickly as possible. You say, no, I need lots of time to prepare for my application. But that having been said, we operate in terms of the rules of the court, and we operate in terms of the inherent powers of the court to manage a case before it. And that's what I'm trying to do. And that is what I am doing and will do. When I said the timetable, if anything should arise, that clearly shows that things are not being done well, I'm prepared to consider that. I have considered your application. This application, according to counsel and according to the rules they were referring to, this application must be heard quickly. It's an interlocutory matter. It must be heard quickly, and a decision reached within 30 days. The idea is to ensure that interlocutory matters are disposed of as quickly as possible so that the main trial proceeds. So, while I can sympathize with the conditions you are or you operate from in the Windhoek Correctional Service, it's beyond me. It's beyond me unless there is an application before me to say that we are being mishandled, we are being disadvantaged in this way, and we want a court to decide whether it will be this court or any other court. I can't just willy-nilly go around saying, please don't give them this, please don't do this. You are under the custody of a certain department of government with its own rules. And those rules can be changed only if a court of law says they must be changed. Yes. Otherwise, you operate within the environment in which you are.
Yes.
Yes. And All I can say, I've heard you. Unless you have anything else to say, my timetable is set. You are going to file papers if you wish a reply. We don't even know whether you'll find it necessary to file a reply. You might find it unnecessary. It might be necessary, but for an urgent matter, a matter which must be heard within a very short space of time, I think the timetable I've set is reasonable, and I will stick to that timetable.
Permit me, Judge, to just set the record straight. I want to disabuse you, if I may, of the notion that I do not want this trial to start. I want to disabuse you.
I've tried to disabuse you also of the notion that I want this trial to be speedily dealt with.
Yes, and I
can assure you, I will. You don't have to persuade me. The point of the matter is, as I say, when people make their applications, I don't interpret them as a way of trying to delay. I look at the applications and deal with them as they arise.
Yes, because
and I said even in my earlier judgment, some of these applications have the result that the main trial will be delayed. But that is the nature of things. If you have a legitimate application before me, we'll deal with it.
And I was of the view that I have not brought an application before this court that does not have substantial issues. The fact that the court finds me wrong does not mean that they are not at least arguable issues, and I hold them dear.
No, that is quite in order. That's why we deal with those applications.
Yes, which is why, Judge, I was happy to hear you say that you apply the rules and then you manage. I just wanted to read Rule 1, Sub-Rule 2 for you. It says the following: these are rules for the conduct of proceedings in the court and for giving effect to the provisions of Article 12(1) of the Namibian Constitution, and the overriding objective set out in Sub-Rule 3 governs the application of these rules. Judge, the rules speak of 12(1). I'm speaking of 12(1), that in this application, it too requires that I have a substantially, and Article 12(1) also says, to adequate time to prepare for the trial. I don't believe you're giving me adequate time, Judge. I will state that. But lastly, Judge, what pleases it, but when asked to do things otherwise it wouldn't, and this exercise would become a charade. It would become just a process, a tick-off box, which is asking of me the question. It looms large before me. Why should I even bother then? Because it seems fait accompli. I will be detained throughout the trial. Whether or not I have a legal representation or not, the trial will go ahead. Whether or not there are circumstances,
can I ask you one question about legal representation? That matter is before the Supreme Court now, isn't it?
Yes.
When are you going to have your legal representation in order?
You see, Judge, if I would be able to answer that question, it wouldn't even be necessary for you to ask it, because I'd solved the issue, isn't it? But we have a situation where two organs of state here.
When everything's said and done, when do you anticipate you will have your legal representation in place? When do you anticipate? Everything's said and done.
The way I understand your question is saying, if you have your legal representation in place, when can we start the trial? Is that what you're saying?
No. When do you anticipate to have your legal representation in place?
You know, I think, Judge, I've misled you if I've made you believe that I have a magic ball where I can just make things happen. I don't. I am in a situation where I'm saying this. What I do not want is for me to be tried in a case of this complexity, of this magnitude, without legal representation. And I feel as if that the court, regardless, will just preside over this matter. And
no.
This I'm court, fighting the court and Marondetse.
This court will be more than happy to have you represented by a lawyer.
Yes, Judge.
And I'm asking, that process of getting you to have legal representation, how long do you think it will take just to secure your legal representation? And I can see you are saying either you don't know or you can't even anticipate.
Okay. It will take me, if I have nothing else to consider, like rush days like this, 3 weeks to draft my papers for an application. I file it. I will not take the risk of it being filed on an urgent basis, so it's knocked out. So it'll probably it'll probably be heard 6 months, or case managed 6 months from there. Then by the 8th month, we have a date for argument. Then it's argued. Then there is a judgment. 11 months later. This is the nature of the...
No, are you answering my question or
Yes,
not?
I am. I'm trying to tell you that then that matter will be determined, because my legal fees, what I'm talking about legal representation, will be through an application I intend to make. And then that application, I do not, because the courts are independent, they may take the decision they take. So again, I'm saying that prescience is just not humanly invested in my capabilities.
So you are unable to tell me an estimate of the time you think you will have
I've given you an
obtained
estimate, 11 months.
from now.
No, now I have to first consider these dates that you're rushing me into, and then so we can, and then Friday I have a matter. If that other matter is also heard, then remember, even if, by the way, Judge,
Is it from now, 11 months from when?
from that date, but I just want
Which
to make
day?
this point.
Which day?
I just want to make this point, Judge. That will be the date determining, because that's in your hands. No, not in your hands. It will be an application in another court. I do not want to be tried behind these burglar bars, because I believe I'll not get a fair trial. I put it before you before. I've written to the registrar, and that it's gone on deaf ears. When I talked to you, you had committed you'd raise it, or you said you'd do something. Zero. You've come back with the impression in my mind that you will soldier on, Deutsche Bahn, with this trial regardless. And I just wanted to, I've read you that part of the rules, that the court applies, it's the court's rules, it's not my rules, the court's rules. That you jettison them now is something else. Thank you.
I still haven't got I still don't understand what your answer is to my question, unless you are saying you don't know. When do you think you will have put in place your legal representation, taking everything into account?
Taking everything into account, based on the unpredictable events, or I still think 11 to 12 months is realistic if I make that application.
From what day? Calculated from when? 11 to 12 months, calculated from when?
From when I make that application. And I can only make that application after we've disposed of this matter. Because for me to now go on full steam, full throttle, I can't.
So we are saying from perhaps end of September.
It's possible.
That is another, so for another 11, 12 months, you reckon that your trial should not commence?
I reckon that I will be busy trying to obtain legal representation.
And the trial should not proceed?
Definitely not, and definitely not from this venue.
Sorry?
Definitely not, and definitely not from this venue, where I am already behind the burglar bars.
Right, so I can note that you anticipate, you would want the trial, to the best of your judgment, you would want the trial to commence in about 11, 12 months from end of September.
No, Judge, because if on that 11th month, I obtain legal representation, would that lawyer not require a period to prepare?
That's what we are talking about, everything taken into account.
Oh, goodness. Then we must then factor that in. Once a lawyer then comes on board, considering that there's 165,000 folios in how many files? 147 files. Considering the fact that I'm still hopeful that we'll get to a point where disclosure will eventually be fully made. And I say so because I know certain documents were taken from my house and I have not yet seen them. And I want to have them because they are exculpatory. So, considering that that person would then have to read them, doing nothing else, read them, consult with me, maybe another 6 months, 6 to 7 months from there. Because remember, Judge, some of counsel here have been with this case from the beginning. That person has to read all those records, look at what's been said in all the bail hearings, etc. If they're really going to be doing a thorough job.
So you're saying to the 11 to 12 months, you add another how many months? 6 months?
The 8 months that I told you, remember I told you that if we are ready, everything, all things considered, I would personally need 8 months to consider all the documents and consult. Those months haven't changed. Add those now to the 11 months.
So when do you think this trial should start? When everything's said and done? That's I can't repeat the same question. When do you think your trial should commence? Everything said and done.
When everybody is legally represented and the legal representatives are ready. You are asking me a question in that realm. I must answer in the vague realm that you're asking.
You have no estimate of time, or we keep it at 11, 12 months from the end of September.
I can't give you a precise date, Judge. I'm just not humanly capable of doing it.
I don't want a precise date. I think we've canvassed the point. I hear you. You consider that this trial can ideally start unless you are able to obtain legal representation earlier. Otherwise, you might require 11, 12 months from the end of September for the trial to commence.
If you may, Judge, since we are coming to argue this matter, it's part and parcel of the issues that are covered in the application for separation. I'd like to come to address that specific matter after full reflection, and I've looked at all things, etc., so that I can give you something that maybe perhaps assists the judge better than what I'm doing today.
So on a lighter note, I'm wasting my sympathies when I sympathize you behind bars, in custody for 4 years, things must move
But you can do something about it. You just don't do something about it. So the poetry is good poetry, but then you act in prose. What's the purpose?
What can I do about it?
You, being the court, are vested in the powers to order that this is removed, period. And you make an order. Let's see if it will not be complied with. What is so difficult with that? You can also say, hold on, Judge, let me just explain.
Have you placed an application before me for that?
And this is the point I'm making. You do not always require an application.
I want an application writing on those points. It's a matter that involves other government departments. I'm not going to simply order that you remove that cage. Someone must tell me why that cage is in place. What are the security implications? What are the physical implications? Someone must answer. You got to write, to file an application, save it on the appropriate people, the people who put up this court. You save them with that application. And they tell us why they subject you to what they have subjected you to.
Okay. I think that's clear. I understand
so
that.
I have always said I'm very ready to entertain an application which is within my province, provided it's properly filed, served on other interested parties, and we deal with it. Mm-hmm. Similarly, the conditions you find yourself in prison, yes, if you make an application, a proper application for those conditions to be changed, whether it comes before me or any other court, we are all one court. They will deal with the application. You serve on interested parties. It's not a matter of just saying remove this cage today.
But Judge,
That
when
is
we
the
made
point
that,
I'm making. You
when we
make
made-
your application as you see fit for any relief you want from this court or from any other court. And those applications will be properly considered.
when we made that application, you came to your chambers.
I don't allocate matters to myself. When you make an application, you file it with the High Court.
Well, that's what we did.
Yes, and there are people there in the High Court who decide who is going to handle which matter.
So do you understand my conundrum? You say we must do, we do. It doesn't happen anyway. This is the problem. Thank you.
Well, it reminds us of what you said about the previous Attorney General.
Exactly. Exactly. Thank you.
Right. So, the order I make is the following. That is in respect of the application filed on the 2nd of September. The state or any other party served with the application who intends to oppose the application or whatever other step that party may have in mind to file their response by the 9th by midday on the 9th of September. The applicant to file his reply on the 11th of September, and the hearing will be on the 13th of September. No insistence on written aids of argument. I'm quite happy to receive oral submissions. The
Yes,
court,
the court, please.
yes, the court adjourns.
Please, court.